Hey guys, welcome to the JW and True channel. So we've heard of the news from Norway about the Jehovah's Witnesses deregistration. But what about the Jehovah's Witnesses? How did they take it home? How did they brought that up to the Jehovah's Witnesses? Well, let's have a look at the news at the JWorg and see how, and let's have a look how they spin it. So let's bring that up. So we've got here the Jehovah's Witnesses website, the JW.org, obviously, and it's pretty biased because there's no news regarding Jehovah's Witnesses in the bad context. So it's all good news for the Jehovah's Witnesses. But let's have a look at what they've said about the Norway decision. So it says here, Norwegian court grants Jehovah's Witnesses request to suspend deregistration. Oh, is that so? Well, let's keep reading and we'll see what actually happened. So on December the 30th, 2022, the Oslo District Court granted our brother's request for a temporary injunction to suspend the government's attempt to deregister Jehovah's Witnesses as a religious community in Norway. This became necessary because the county governor of Oslo and Viken announced her decision to revoke our national registration. The injunction allows us to keep our registration until the matter is further considered by the court. The Ministry of Children and Families is challenging our injunction. So, is that what actually happened? Well, let's have a look at the court papers, which we got here, which is in Norwegian. I've got all these to download. If you want it, I'll put a link down in the description for you to download them. So we've got here the Norwegian court papers. So let's translate to the English. We're using Google Translate to translate all these documents. So now that we have the translation documents here, let's have a look what these papers have to say regarding this injunction from the Jehovah's Witnesses. Let's have a look if these papers actually matches what the Jehovah's Witnesses says in the website. So let's check this out. So let's go to page 9. The first 8 pages, it just talks about what the Jehovah's Witnesses has said about their own history, how long they've been registered for, and then the appeal was denied or was rejected, and then they were deregistered, and they're pointing out the errors from the Oslo administrative decision and blah blah blah. So now here we got the district court response on about the injunction. So let's have a look if what they said previously in the Jehovah's Witnesses website matches this. So let's read this one and let's pay good attention about this part. So it says here, the court has found that there is a risk of delay and has made a decision in the case without the parties. Pay attention to this bit. In the case, has made a decision in the case without the parties having been summoned to an oral hearing. The Disputes Act section 32(7) second paragraph. For the same reason, the defendant, which is the Oslo administrative, that made the decision about the Jehovah's Witnesses, which are the defendants here, was also not given the opportunity to make a statement before the decision was made. So they have sued the department and put an injunction. So now they're saying here there's going to be a risk of delay because this injunction was done on the 28th of December 2022. So they've got 1 or 2 days maximum, depending on what time they lodged this and the time they received it and it was processed. So they might have had 1 day only. So they're saying here that the defendant has also not given the opportunity to make a statement before the decision was made. So no decision was made according to the injunction from the part of the Jehovah's Witnesses. So let's have a look at the second point here. The competence that follows from this legal provision in section 2042 of the Public Administration Act belongs to the executive power, the administration, not the judicial power. So they're saying here that belongs to the administration, not the judicial power. In this case, The court cannot put itself in the place of the state administrator of the ministry, and decided or defer implementation on the decision on the 22nd of December 22 on the basis of the Section 42 of the Administration Act, which is fully subject to the administration's free decision. The matter of the registration is also not as such of nature that it naturally opens up for assessment in the direction that the administrative decision is based on abusive of authority. So we can see here that the court has not looked at this case itself at this point. This is important. They have not considered the law of the process, but the judge says there is no assessments that the state has abused its authority. So let's have a look at the third point here in these papers. Whether the decision on laws of registration is an invalid administrative decision triggers demanding factual and legal assessments. The adjacent question about the loss of state subsidies for 21 stems from the same legal facts as in the registration case here, and has already been brought into the lawsuit process with pending judgment. The district court now has no opportunity during Christmas. Did you see this? The district court now has no opportunity during Christmas without the possibility of a contradiction with the other party before the turn of the year to carry out the proper assessment of the plaintiff's claim. Plaintiffs are the Jehovah's Witnesses now. Claim of invalid registration refusal. This was also mean that the plaintiff has no proof that the decision is invalid, nor proved a main claim. So here we can read that the judge says for himself that there is no proper assessment made over anything yet. So let's have a look at the fourth point here. The plaintiff, Jehovah's Witnesses, has focused particularly on the fact that the legal effects of deregistration, such as loss of marriage rights, loss of reputation, and accompanying stigmatization of the religious community will hit Jehovah's Witnesses very hard. The provision leaves it to the court to apply an overall judgment when this exception rule is considered to have been used. The court is pressed for time, and on the last working day of the year before the decision on the 22nd of December 2022 comes into force from the beginning of January 23, the court can hardly see that weighty administrative considerations should prevent the deregistration decision from being temporarily suspended. At the same time as a suspension, or nor can the decision in any concrete way be seen to expose society to any form of concrete nuisance. So here the claim was made so that the courts had 1 day to decide, the last day of the year. The courts accept a temporary suspension because there is no time to process the claim. And the fifth point here, the judgment here is not binding until the question of validity has been legally decided, but until the courts decided otherwise. So the decision is only valid until courts decide otherwise. This could be the next hearing, or if the state objects, or it could be until the courts have made a judgment. We will have to wait and see. So let's read this last paragraph and compare it to what the Jehovah's Witnesses said on the website and see how different it sounds. Let's read what the court notes here says. The plaintiff, which is the Jehovah's Witnesses, has been heard using a rarely used exception rule on the temporary protection. While it has not been proven that the general conditions for the use of a temporary injunction has been met, based on these circumstances, the court does not find it possible to award the plaintiff, Jehovah's Witnesses, the alleged legal costs in the injunction case here. Disputes Acts 20/2, third paragraph, letter A, stating that they are considered to be weighty reasons for exempting the defendant for responsibility for costs, especially when the exception rule is applied and where the defendant has not been heard. combined with the fact that the claim as such appears to be doubtful. Combined with the fact that the claim as such appears to be doubtful. So they're saying that the claims that Jehovah's Witnesses are arguing for sounds very doubtful. So how does it sound? Does it sound the same as what Jehovah's Witnesses said on the website? Let's read it very quickly again, and let's see what they said on the website. The Norwegian court grants Jehovah's Witnesses request to suspend the registration. Is that a grant? It doesn't sound very similar to what the paper said. So it says again, on December the 30th, 2022, Oslo District Court granted our brother's request for a temporary injunction. That's not what it said in the papers. It was very different. So it's quite interesting to see how the Watchtower or the Jehovah's Witnesses spins their news to make it sound like, oh yes, we won a injunction, or we won a temporary what is that, deregistration. But in fact, the facts are very, very different once we go to the papers and to the court's papers and see for ourselves why the decision was granted or why the decision was implemented. So yeah, well, let's stay tuned and let's see what we can find for the next video.